Assalamualaikum. Our group will present about the case that related with our title, Validity of Contract. I am Shakira and I will start my presentation on components of validity of contract. There are 6 components that determine whether the contract is valid or not, which are offer and acceptance, consideration, intention to create legal relation, certainty, capacity, and the last one is legal or concern. This case is between Spring Energy Sdn Bhd and Maju Holdings Sdn Bhd. The plaintiff is Spring Energy Sdn Bhd and the defendant is Maju Holdings Sdn Bhd. The plaintiff is a subcontractor, meanwhile the defendant is a main contractor. Next is identification of case. The plaintiff primary claim is RM331,397.23 based on the works that were completed and paid for using progress payment certificates number 22 and 23. According to this statement, the issue in this case is the legality of the contract given that they have consent from both parties. Then, according to Order 14 Rule 1, the plaintiff can only apply to the court for summary judgment after he has served the statement of claim and the defendant has entered an appearance. This case that was brought to court in 2019 was brought because of the defendant having made late payments to the plaintiff. In this circumstance, there are a great deal of issues resulting from the agreement in the letter of award from both parties. So, that's all from me. I will pass to the next presenter.
I am Nursakinag and next I will proceed with facts of the case. The chronology of this case starts when Maju Holdings issued letter of award to Spring Energy to conduct the works. On 6 September 2016, Spring Energy reached agreement with Maju Holdings to become subcontractor. As a retention sum, Maju Holdings kept 5% of the total amount for themselves. On 19th January 2018, the Spring Energy finished the works and submit their claim regarding retention sum, but Maju Holding only released half of retention sum, which is 2.5%. On 27th March 2019, Maju Holdings issued a certificate of making good defect. It is noted that the total amount of works carried out by Spring Energy amount around to 13 million ringgit and this amount does not surpass the maximum price. Maju Holding not yet paid Spring Energy total of around 300,000 ringgit due progress payment number 22 and number 23. In letter of intent, Maju Holding claimed that amount of money to be paid should based on quantum merit, which means it should be reasonable and calculated based on the going rate for the labor and service that is being provided. Besides, Maju Holding argued to Spring Energy that the payment will not release until they done carried out final remeasurement and determine final value. Spring Energy agreed with the argument, but Spring Energy assert that the final measurement was finished after they were provided with final statement of account. Final value has validated and Spring Energy has given approval. After that, Maju Holding filed appeal in accordance with Order 14 against Spring Energy that no agreement had been reached on the terms of payment. However, the court find it wrong to withhold the retention sum from Spring Energy because the purpose of the sum was to ensure that the works were finished in their entirety, and it is clearly shown that Spring Energy has completed the work as stated in the contract. In a nutshell, the court has concluded that Maju Holding has not presented any legitimate issue. They just find excuses to avoid or postpone payment. That's all for the facts of the case. Next, I will pass to the next presenter, which is Naqib.
Thank you. Hi, my name is Mohamad Najhan bin Mohamad Nazri, and here I will present about the decision by the courts. The full judgment decision was issued by Kuala Lumpur High Court Judge On Chi Kwan on 21st August 2020. The case between Spring Energy and Maju Holding, where the defendants filed an appeal against the court's decision. Nevertheless, the court held that the plaintiff has established a clear-cut and a prima facie case, and the defendants is merely a bare deniers. No bona fide tribal issue has been raised by the defendants. The court went through several considerations in the defendant's application under Order 14 in dismissal, which was strengthened by the reference of the Courts of Appeal (COA), in Ismail Abdullah versus Tenaga Nasional Berhad in 2010. The court finds that the plaintiff has complied with all the requirements under the Order 14's Rules 1, Rules of the Court. Undoubtedly, the defendants only has to raise excuse simply to refuse or delay the payments to the plaintiff. That's all from me. Thank you. Next, I will pass it to the Hakim. Bye.
Assalamualaikum warahmatullahi wabarakatuh. My name is Mohamad Zafarullah Roslee. Today I will conclude the case between the Spring Energy Sdn Bhd and Maju Holding Sdn Bhd. Maju Holding Sdn Bhd issued the LOA to the Spring Energy to become subcontractor for the certain project. Then the both parties agreed to make a legal relationship between them. Next, after the Spring Energy Sdn Bhd done all the work in the given time period, Maju Holding Sdn Bhd did not make any payment after the certificate number 22 and 23, including the retention sum and the final statement. That cost almost 300,000, like that. That's why Spring Energy sued the Maju Holding, but Maju Holding counterclaim that there is no agreement between them and no contract between them. However, the court find otherwise, that that date the letter of award that be issued, there is clerical error by the Maju Holding Sdn Bhd itself, because the content of the letter of award contain the date and the reference and all the scope of work. Court find the letter of intent that mentioned by Maju Holding is intent to become the letter of award. So after that, court find the Spring Energy entitled to the sum of the progress work and the retention sum, because Maju Holding failed to prove the Spring Energy not entitled to the claim. From what I can see, Maju Holding is just want to avoid or postpone the payment and maximize its profit. Next, a lesson that we can learn from this case is we should not suppress any other party, because it is an appropriate act to be done. Next, any other contract document should be clearly written so no issue will happen in the future. Just like the case from Maju Holding, the clerical error by the Maju Holding itself show that some misword used in the contract can be create a problem in the future. And finally, we should not find any excuses to run from that and postpone the payment, just like Maju Holding did to the Spring Energy Sdn Bhd. And I think that's all the lesson that we can learn from this case. Thank you and Assalamualaikum.